Good morning, good evening, good afternoon. Happy Tuesday. I have an ex parte this morning, so early hearing. But you don't care about that. So some interesting news. I'm going to start off with Mata, Manuel Mata. He's a CJ Grisham acquaintance. In every criminal case that I've seen with Matthew Mata, and I don't follow it particularly, but every once in a while, I'll get something coming across Discord or whatever about Mata. And if you don't know who Matthew Mata is, he's like a First Amendment agitator. He likes to go into like county council, whatever they call them in Texas, meetings and disrupt and film and get trespassed and cause a scene, blah blah blah. And he's had lots of interactions with law enforcement, lots of arrests. I think lots of convictions, but I don't follow him, so take that with a big grain of salt. But every time I see him in a legal case, in a criminal case, he's been represented by Grisham, CJ Grisham, Chicken Hawk, as CJ calls himself for reasons that I don't understand. I know the backstory that Chicken Hawk is that little cartoon character who plays the opposite of the giant chicken. And, I'm a chicken hawk and you're a chicken. And he's going to eat the chicken, and he never does. But CJ alleges he got that as a nickname in the Army because he was tiny and tough. Who knows? Obviously, there is the homosexual reference to Chicken Hawk. So, I mean, why he would choose that name is beyond me. But I guess he likes it. Anyway, CJ represented Mata in all of the criminal cases that I'm aware of, but now Mata has an actual legitimate case, or at least it appears that way from the complaint, wrongful arrest, First Amendment retaliation, yada yada yada. It appears to have legs. I mean, if everything in the complaint is true, and I have no reason to believe it's not, at this point anyway, it's a pretty good case. And weirdly enough, CJ Grisham isn't the attorney of record for that. I wonder why. Is Mata not confident in Grisham's ability to represent him in a civil case where there might actually be a recovery? And I'll bet you that Mata is being represented on a contingency basis. I will bet you. Because, I mean, it looks like a good case. It looks like it has legs. It looks like there's going to be some sort of a settlement out of it. I doubt it's going to go to trial, but it looks like there's going to be some sort of a settlement out of it. And, yeah, that's the kind of cases attorneys like to get. I mean, good money for relatively little work. And interestingly enough, in the, Caroline in Fort Worth case where she was body slammed by the cop, I would have taken that case on contingency for excessive force. I definitely would have taken that case on contingency. And CJ Grisham definitely wanted to take that case, and he's had a lot of interaction apparently with Caroline in Fort Worth. And he was all over it, at the beginning, talking about how they were going to sue, and then she went with another attorney. So I'm like, why do all of the people that CJ Grisham has probably professional relationships with, at least from criminal cases. I don't know that he represented Caroline in criminal cases, but he's had a lot of interaction with her. Why do they all choose different attorneys to represent them on the civil cases where there is a substantial probability of getting a settlement? I wonder. Obviously, it couldn't be a reflection on CJ's abilities as a lawyer. I think he's still a probational attorney. Yeah, I think his license is still probational, which is strongly indicative of disciplinary action. I mean, you don't get a probationary license if you're a squeaky clean good attorney, right? I remember when he was going to sue the judge on a case where he argued that a firearm should be returned, and the judge disagreed with him, and he was going to sue the judge. That was hilarious. He took all those videos down, so you can't find any record of it other than me commenting on it in my videos, but that was hilarious. He would never admit that he was wrong. He just quietly eliminated all of the references to it out of his back catalog. I don't eliminate my videos. All of my videos are up there, even the ones where I've been dead wrong in, because you know what? I said it and I'm sticking by it. I mean, I admit when I'm wrong, or at least I try to. But, there's a difference between me and CJ Grisham, and it's not just that I'm way more handsome than he is. But none of you really care about CJ Grisham or Manuel Mata. So let's talk about why you clicked on this video. So the first day of trial in Jose's case, Jose Maria Decastro's case against LVMPD was yesterday. And a couple interesting things. First, Anderson, not the new guy, Dickinson, who was the former chief DA for, I think, Las Vegas County, or whatever county, Clark County in Las Vegas, I think it is. Anyway, Anderson was the attorney who was doing the cross-examination, which I find to be interesting. I am left wondering what Dickinson's role is going to be. I wonder if Dickinson is going to be on direct examination, if Anderson is on cross. I wonder if they're going to switch up for different witnesses. I wonder if there's a particular witness that they're bringing Dickinson in to conduct the examination of. It's right now, they brought him in really late, so I don't think that he would be doing like trial prep or evidence work or anything like that. So I'm just left wondering what his role is. And you might not find that interesting, but as an attorney, I do. The other interesting thing is that apparently Decastro made a 13-minute video. I didn't see it. I only have secondhand reflections of it on my Discord. But apparently, according to the people who watched it and filtered it through to me, so, take this with a huge grain of salt, and apparently he deleted the video, so I'll never see it. But apparently he is very concerned that he might lose because one of the jurors is married, I guess, to a retired cop, and he is conjecturing that particular juror might be abused by that cop or something along those lines, by that retired cop. And that's, if there was actually anything to that, if there was something to that, if Michael Mee, Chili's attorney, could have shown that juror was actually biased, that juror would have been excused for cause. That juror was not excused for cause, so take everything that Chili is telling you about that juror with a giant grain of salt. Just because you are married to a retired cop does not necessarily mean that you are going to be biased. I know a lot of people like to say, of course they'll be biased, but will they? It's a different legal standard. I think Chili should be much more concerned with just the allegations that he's making and the lack of damages that he's going to be able to show. Those, in my opinion, are much bigger concerns than whether or not a juror is married to a retired cop. Another thing that I found interesting is that Michael Mee chose, this is a strategic decision, so, he may be right, he may be wrong. I'm just noting it because I wouldn't have done it. That doesn't mean that Michael Mee is wrong for doing it, but I wouldn't have done it. Michael Mee led with one of the defendants. He called him as a hostile witness, so that was the first witness called. That was the only witness that was heard yesterday. I think that's a bold strategy, Cotton. Let's see how it plays out for him. Normally, my strategy, and again, I'm just a first-year family law attorney. I'm not an attorney of Michael Mee's caliber or anything like that, but my normal strategy on a contested trial like this is to bring up my client first. In my experience, from my understanding, the first set of facts people hear tend to set the standard. In my experience, Michael Mee's experience may differ. They get the story from my client, if I'm allowed to go first, and then if I am going to call any hostile witnesses, if I am going to call, for example, a defendant or a respondent or whatever, then I'll call that witness. But the jury or the judge, whoever the finder of facts is, will already have a story that I have told through my witness from which that cop is so unhealthy looking. Boy, he's a blob. Oh, he ain't running far after any crooks. But there's already a narrative in place, and every subsequent narrative is going to jar where it differs from my narrative. And then the defense has they have the burden of essentially undoing my narrative and providing an alternative narrative that still encompasses my facts. So it's a strategic decision. He might be calling that particular witness first so that witness doesn't have, because you can exclude witnesses, but you can't exclude parties. And that witness is a party. Maybe he's trying to get all of their stuff out of the way so they can't hear and rebut. I mean, unless the defense is competent enough to excuse them but reserve them for rebuttal. Not excuse them, but instead of excusing them, reserve them for rebuttal. So maybe he's just trying to get all of their testimony out of the way, so then his client essentially gets the last word before the plaintiff rests. It's a strategic decision. I think it's an interesting one. And again, I can't say he's wrong, but I can say that I wouldn't do it. Now, again, you get 3 attorneys talking about the same facts. You're going to get 4 different opinions on how the case should be tried. The weird thing is that one of the attorneys I work for is medically unable to do a trial, and he still wants to be involved in trial prep, and he's trying to tell me how to conduct the trial. And I honestly don't understand his theory of the case, and I don't understand the argument that he's making and that he wants me to essentially make at trial. So that's going to be interesting. But like I said, every attorney has a different way of doing a trial, a different way of conducting examination. So, your mileage may vary. But it'll be interesting to see the way this goes. If Chili keeps posting videos about how he's concerned, well, that's not a good sign. But anyway, I still give Chili very low odds of success at trial. I know a lot of people think that the wrongful arrest is still in play and that somehow Chili's vindicated. The officers already have qualified immunity for that. That was decided on summary judgment quite a long time ago. The wrongful arrest, he has, I believe, still on the table, First Amendment retaliation, the big ones, First Amendment retaliation and excessive force. But he has a real damages issue with excessive force. He doesn't have an expert to put on the stand for excessive force to show the extent of the injuries or anything like that. Basically, he has a picture of a bruise and I think $150 charge to go to a doc in a box to have a picture taken of a bruise that they didn't even treat. So again, he doesn't, to the best of my knowledge, he doesn't even have an expert witness like a law enforcement, retired law enforcement, or another law enforcement officer to testify about the proper procedure for detaining someone and for pressure points and things like that. I don't see how he's going to prevail on that. I really don't. And as far as the First Amendment retaliation, that's a pretty big burden. He's going to have to show that similar people in similar situations were treated differently. And I don't know that he has anybody to testify about that. So again, I just don't see a path to winning for him. I just don't. I'm not saying he can't. Like judges, juries sometimes come up with some crazy shit, and you expect a loss, but because of something on the jury, they end up pulling out a win. But if Chili isn't liking the way the jury was selected, if he thinks that there's jurors in there that are going to be biased against him, that he couldn't get removed for cause, challenged for cause, then it's. I mean, good luck to you, Chili. Good luck, and I mean that. Like, good luck. You got a lot of losses. I mean, I'm hoping for a win for you. Anyway, thanks for watching. Have a great day.